Wait till she. Let's go.
Welcome everybody. I'm Dr. Swee. I'm the current president of MSNJ, and I'm glad to have you at our meeting tonight uh, to talk about a very important and timely topic. The ACA, Section 1557, and its implications for all of us in practice, all of us who are seeing patients, all of us who are taking care of a wide variety of people. And almost all of us work in settings where there are a number of people to make this very complicated. So I'm going to be introducing Tom Sullivan, who will then introduce our main speakers. Um, Tom, if you haven't heard him before, is an expert in CME. He has been uh, dealing with problems with policy and procedures for many years. He currently serves as the Senior Vice President at Clinical Education Alliance, and he focuses on regional association relationships. He's renowned for his expertise in policy compliance, as evidenced by his role as the editor and author of Policy and Medicine, a website that focuses on regulatory and compliance issues for the healthcare, pharmaceutical, and device industry. Now, I'm not going to read all of his bio because then you wouldn't get a chance to hear from him or his colleagues. So I would just at that point stop and say, turn it over to Tom, and I will ask Tom to take over the meeting.
Well, thank you
Thank
so
you,
much.
Tom.
Thanks, Dr. Swee. I just want to introduce two esteemed colleagues that I have with me. One is Stephanie Doyle. She's an associate at Baker Donaldson, a law firm that's a global law firm. Stephanie counsels long-term care and other clients nationwide in matters involving federal and state regulations, licensing, survey, and certification, and regulatory compliance. She began her legal career as a law clerk for Brian Jackson, a chief judge of the U.S. District Court for the Middle District of Louisiana. By attending American University School of Law, she also served as a judicial intern for both Richard Roberts, who was the chief judge of the U.S. District Court for the District of Columbia, and Gerald Bruce Lee of the U.S. District Court of the Eastern District of Virginia. Prior to beginning her legal career, though, she had held several positions in health policy and advocacy, including Director of Government Relations at the District of Columbia Hospital Association and Health Policy Analyst for the American College of Obstetrics and Gynecologists. She also earned a master's degree in public health from Tulane University Public School of Tropical Medicine. Also joining us is Alexandra Moylan. She's a shareholder at Baker Donaldson, and Alex is a seasoned healthcare and business attorney with a track record of representing major medical systems and healthcare providers, life science companies, and other businesses. She advises them on governance, risk management policies specific to AI, and provides corporate education on AI. As a certified information privacy professional, she advises clients on navigating the complexities of compliance with data privacy protection laws and collection and use of processing of personal data. So this is like near and dear to her. She's also a thought leader and has contributes to many lectures in many venues. So with that nor ado, I'd like to just quickly set up ACA Section 1557 of the final rule was just released about a month and a half ago, and it will be effective July 5th. So this is coming on us very quickly. So without further ado, Stephanie, I think you're the first up. If you can start and let us know what this rule is and go to the next slide.
Thank you, Tom. I appreciate it. As soon as we get the next slide up, I can go ahead and get started. Thanks. Okay, so Section 1557 of the Patient Protection and Affordable Care Act. Section 1557, as it says on the screen, prohibits discrimination on the basis of race, color, natural origin, which also includes language, age, disability, or sex, which includes pregnancy, sexual orientation, and gender identity, and covered health programs and activities. But what does that actually mean? Next slide. It means that the nation's first federal civil rights law to focus exclusively on non-discrimination in healthcare and to prohibit discrimination on the basis of sex in healthcare is Section 1557. It prohibits that covered entities that administer health programs and activities from excluding from participation, denying program benefits, or discriminating based on certain characteristics. The characteristics are going to be listed on the side of your screen because Section 1557 actually works, incorporates, and enforces based on 4 major civil rights laws that already exist. Title VI is the Civil Rights Act, which prohibits discrimination based on race, color, and national origin. Title IX of the Education Amendments, which prohibits discrimination based on sex. Section 504 of the Rehabilitation Act, which prohibits discrimination based on disability, and the Age Discrimination Act, which prohibits discrimination based on age. Next slide. Now, we've gotten a lot of questions about why Section 1557 even exists. The goal for Section 1557, the kind of public health and policy goals, are to expand access and healthcare coverage, eliminate barriers, and reduce health disparities. Next slide. The legal goals behind it are to apply the non-discrimination protections to telehealth and patient care decision support tools, including artificial intelligence and machine learning, and to recognize the protections against discrimination on the basis of sex, including sexual orientation and gender identity, consistent with the very important Supreme Court holding Bostock v. Clayton County. So the most important part of the slide is the part in red. Covered entities are health programs and activities that receive federal financial assistance from the U.S. Department of Health and Human Services. With the 2024 final rule that was released in May, this includes recipients of Part B funds. That was not the case of the prior rules that we'll go through a little bit regarding earlier that were released in 2016 and 2020. So this means that covered entities must provide equal access to health care, health insurance coverage, and other health programs without discrimination based on protected characteristics. Next. To go through a little bit of the history and to give you more detail on the 2016 and 2020 rules that I mentioned earlier, the U.S. Department of Health and Human Services released the first rule regarding Section 1557 in 2016. Now, I'm not going to go through everything that was in the earlier rule, but I'll talk about 4 particular provisions that have kind of flip-flopped back and forth between versions of the rule. The first one was what the definition of sex is. And under the Obama administration rule in 2016, we're required covered entities to provide equal access to health programs and activities without discrimination based on sex, which included sex stereotypes and gender identity. What it did not do, as the second point, is resolve whether or not the statute prohibited discrimination based on sexual orientation status alone. It also did not have a blanket religious exemption related to the statute's general prohibition on sex discrimination, and it interpreted the statute to allow a private right of action and compensatory damages. Next slide. In 2020, the Trump administration reconsidered the regulation and reversed several of the original provisions of the 2016 rule in its 2020 rule. It eliminated the general prohibition on discrimination based on gender identity and sex stereotyping, using a binary male and female definition of sex. It did not recognize discrimination on the basis of sexual orientation status alone. So the Obama rule left that undetermined, and the Trump rule just did not recognize it. The Obama rule and the Trump rule just did not recognize it. The 2020 rule did adopt a blanket abortion and religious freedom exemption for healthcare providers, but it also eliminated the provisions affirming the private right of action so that the courts would have to decide whether or not it existed and whether or not individuals could challenge alleged violations of Section 1557 and obtain money damages to the courts. Now, the courts actually have decided this, and they've decided that the private right of action exists under the statute, not the regulations. So even if the regulation changes again, the private right of action will remain. As of 2021, the Biden administration interprets and enforces Section 1557 prohibitions on discrimination based on sex to include discrimination based on sexual orientation and or gender identity. Next slide. So the 2024 rule, which is the Biden administration rule, has a couple of key requirements. The first and most significant change in the rule, when compared to the previous versions, is in the expanded definition of sex as a protected characteristic. So it prohibits covered entities from imposing restrictions on care provided based on a patient's gender identity or sex assigned at birth. It also includes, and this is particularly relevant here, Part B recipients as covered entities. So that means the reason they did this is because they kind of reinterpreted the definition of federal financial assistance. They didn't change the definition, they just reinterpreted it. And the primary argument behind it is that the government is assisting providers of services by making available to them a segment of the population that would either not be able to afford medical services or wouldn't be able to afford medical services from these providers. And since the government through Part B provides a reliable source of payment for services and also covers half the cost of Part B benefits, they feel that they can reinterpret the regulation to include Part B. The rule also requires that practices take a number of affirmative actions to inform patients of their rights and protect them from discrimination, and we'll go through these later. It offers expanded assistance for individuals with limited English proficiency and disabilities, and requires providers to make reasonable efforts to mitigate discrimination and patient support tools, which Alex is going to go through a little later on in more detail. Next slide. So Section 1555 is enforced by the Department of Health and Human Services Office of Civil Rights, OCR for short, and we're going to talk a little bit about the consequences of noncompliance. When OCR finds a violation of Section 1557, it will seek the voluntary cooperation of the covered entity to take corrective action first. So that may include revising policies and procedures or implementing training and monitoring programs to address the particular topic of the complaint. If the covered entity refuses to take corrective actions, OCR may recommend the suspension or termination of the violating provider's federal financial assistance, so basically cutting them out of Medicare, Medicaid, and other healthcare programs, or refer the matter to the U.S. Department of Justice for possible enforcement proceedings. The rule does not specifically address fines or penalties from HHS, but you have to remember that there still is the private right of action under Section 1557. So the provisions of the Section 1557 rule that providers actually have to affirmatively implement are divided into two sections. The first one are the facilities would have more than 15 or more employees, and the second set of requirements apply to all employees or all facilities regardless of the number of employees. The first requirement under Section 1557 for more than 15 employees is to designate a Section 1557 coordinator who will be responsible for carrying out the covered entity's organizational requirements under the rule. Now, this must be accomplished by November 2nd of this year, so 2024. Next slide. So under the rule, 15 employees includes all full-time and part-time employees and/or independent contractors. And the provider must designate at least one employee as a Section 1557 coordinator who will be responsible for serving as an internal resource dedicated to coordinating and ensuring the covered entity compliance with the rule. So the Section 1557 coordinator will have lots of responsibilities, including receiving, reviewing, investigating any grievance communicated by the covered entity, be it from a patient, employee, other source, alleging noncompliance with Section 1557. They're also responsible for coordinating trainings, record keeping, all those sorts of things that we're going to discuss later. The coordinator is responsible for coordinating them. So at least in employers of more than 15 employees, that's going to be that particular person's role. Next slide. Additionally, for providers with more than 15 employees, the facilities must implement written civil rights grievance procedures for its healthcare programs and activities that provide the prompt and equitable resolution, that's a quote from the rule, of any allegations that would be prohibited by Section 1557. So the grievance procedure must be accessible to individuals with limited English proficiency and individuals with disabilities. And again, I mentioned the record retention requirements and keeping the identity of the individual who filed the grievance confidential as part of the coordinator's responsibilities and the covered entity's responsibilities. Next slide. Now, for all facilities, must develop, this is one of several things that all facilities must do, and it's develop and implement written policies and procedures to facilitate compliance with Section 1557. This happens to go into effect on July 5th of next year. Next slide. So the facilities and the providers must develop at a minimum and implement written policy and procedures designed to facilitate compliance with the rule regarding non-discrimination policy, language access procedures, auxiliary age and service procedures, and procedures for reasonable modification for individuals with disabilities. Now, the procedures must include certain things. One is, of course, an effective date, and they must be reasonably designed. OCR will take into account the size, complexity, and type of the facility's healthcare programs and activities, but again, this does apply to all providers that are covered entities. Next slide. Also required by all providers is to post and provide a notice of availability of language assistance services and auxiliary aids and services in English and in each of the area's most common 15 non-English languages to inform individuals of the availability of language assistance services and auxiliary aids and services free of charge. That also has a deadline of July 5th of next year. Next slide. So the language access requirements are some of the, I think, most impactful to providers. The facilities must provide individuals with limited English proficiency meaningful access to services and must take reasonable steps to provide meaningful access to each limited English proficient individual, including their companions, eligible to be served or likely to be directly affected by its programs and activities. There's certain things that the regulation lays out that providers no longer can do if they have been doing them. One is to require a limited English proficient individual to provide their own interpreter or pay the cost of interpreter. They cannot rely on an adult who is not a qualified interpreter, and that has a specific definition that I'll go into in just a minute. They can't rely on a minor child, and they can't rely on staff other than qualified interpreters, qualified translators, and qualified multilingual and bilingual staff. So all three, the qualified interpreters, translators, and multilingual and bilingual staff have to speak at least one language besides English and English proficiently. For qualified interpreters and translators, they have to be able to translate specific phraseology, specific medical terminology without any sort of kind of tone or matching the tone that was actually given in and also matching the emotion. For qualified bilingual and multilingual staff, they also have to be able to use technical phraseology and vocabulary in order to be considered qualified. Now, we got a specific question about Google Translate. The final rule does not specifically state that a provider can or cannot use Google Translate to meet the requirements of the rule. However, one commenter in the rule pointed out that Google Translate incorrectly translated information regarding COVID vaccine that was used on the State Department website. HHS requires that for certain critical documents, such as anything related to the patient's civil rights or anything particularly complex and medically technical, any machine translation, such as Google Translate, must be reviewed by a qualified translator. In addition, HHS recommends that if machine translation is used in circumstances that do not require human review, patients should be warned that it may contain errors. Next slide. The notice availability must state the facility provides language assistance services and appropriate auxiliary aids and services free of charge when necessary for compliance to participants, beneficiaries, enrollees, and applicants of this program activities and members of the public. It also needs to be posted conspicuously and provided in a number of electronic and written communications. So things like discharge papers or notices of privacy practices. You would have to include the notice availability with those particular documents. Next slide. The next requirement for all facilities is to post and provide a notice of non-discrimination to participants, beneficiaries, enrollees, and applicants of their healthcare programs and activities and to the public. This needs to be done by November 2nd of this year. Next slide. Now, the notice of non-discrimination has very specific requirements that are listed in the rule. It goes down to the type of font size you can use and what specifically must be stated in the notice of non-discrimination. It must be provided to participants, beneficiaries, enrollees, and applicants, and members of the public. And it must convey the availability of services and modifications required by the new policies and procedures. And just like the prior notice of availability, it must be posted in conspicuous locations and readily provided. Next slide. I think we had one before this, yes. So one of the other or last requirements for all facilities is to train relevant employees on the covered entities section 1557 policies and procedures. Now this one's a little complicated because the deadline to train employees is no later than 30 days after the covered entity implements its policies and procedures, and no later than 300 days after the effective date of the rule. 300 days after the effective date of the rule is actually May 1st, 2025. You'll remember that it was July 5th, 2025 that the policies and procedures actually needed to be finalized. So you'll need to do some training on those policies and procedures prior to the deadline for the policies and procedures. Next slide. The providers must train relevant employees of the health program and activities in the new civil rights policies. Relevant employees is interpreted very broadly, includes employees that interact with members of the public or residents, that make decisions that directly or indirectly affect residents' health care, including covered entities, executive leadership team, and legal counsel, and employees that perform tasks and make decisions that directly and indirectly affect residents' financial obligations, including billings and collections. Next slide. We also have some provisions on non-discrimination and telehealth. Was there something before this? Okay, next slide then. Okay, and we also have some guidance on non-discrimination and telehealth for joint guidance from HHS and the Department of Justice that was issued in 2022 and already prohibits covered entities from using telehealth in a discriminatory manner. That guidance still stands. HHS is kind of emphasizing its importance in the section 1557 final rule, particularly because telehealth services can be inaccessible to individuals with disabilities. Next slide. So we received some questions prior to the presentation and we're answering them here. The first one was, did CMS provide a billing code for translation services? There is a billing code for translation services. However, it is not covered by Medicare, and whether or not it's covered by Medicaid is going to depend on your state plan and your Medicaid regulations in your state. So it's kind of unclear how it applies to Section 1557's expanded requirements. The second question was, where do we find translation services that are affordable? Unfortunately, we can't recommend specific vendors, but there are some professional organizations that may have suggestions or recommendations.
Stephanie, can I just jump in there to give a little more flavor to that? Because I think that's one of the larger burdens for providers in terms of compliance with the requirements. So if you do look at either individual societies, for example, like the ADA does have some vendors that they recommend for their members, and the AMA has suggestions for potentially, providers pooling together and sort of prorating the costs of the services, the translation services. And when Stephanie was talking earlier about the documents, and if you use machine translation for certain documents, a lot of those vendors can give you information in terms of accuracy rates if it is done by machine translation versus a qualified translator. So those are ways to get more information about compliance with that specific provision.
Thank you, Alex. I appreciate it. Okay, so the next rule after that actually also had to do with the top 15 languages in translation, whether or not the updated informed consent and intake forms have to have the 15 different languages. Now, the rule doesn't specifically discuss informed consents in this context, but it does point out that the notice of availability is required to be provided in English in the top 15 non-English languages, not quote unquote all information. So that's the indication that we're given there. And I will actually hand this last one over to Alex as well.
Yeah, so I know we're going to talk about this, Tom, in more detail, the patient, essentially the tools, whether automated or non-automated, and sort of discrimination that can go on there, and what HHS is requiring of covered entities in Section 1557. But in terms of, what they're really trying to do is there can be bias in algorithms and automated tools often. And so really what this is looking at is what efforts do the covered entities have to make. So if you as a provider are using some kind of automated or non-automated tool. And I think Stephanie and I were talking about this earlier, the most simple example I think that everybody can relate to is when you are doing labs on a person, and if you're looking at the GFR, the eGFR, there can be a race-based calculation that is used in terms of values. And so that is one example that HHS has given as there is an input variable, race, that can lead to discrimination. So that is something that would come under the scope of Section 1557's requirements and be one of the tools that are used in clinical decision-making that could lead to potential discriminatory output because there is a race-based component to it. So there are different things that providers can do, and we'll sort of talk about the efforts and compliance and what is reasonable and best practices for that. But that's a good example. Another example is just lab values generally. If you're talking about pediatric populations versus adult populations, technically those lab values are different, right? They take into account the age of the patient, but that is clinically relevant and important, and it is the standard of care because pediatric populations are not going to have the same lab values as adult populations. So we've put some bullets here, and I believe that the slides are going to be provided to participants in terms of the specific answer to this question, but we'll talk in more detail about best practices in terms of what HHS is expecting for providers who are using patient care decision support tools and how to inventory those, and then where you would look to see, okay, is there a discriminatory output in this tool that I'm using, and what should I implement in terms of best practices for compliance?
Okay, I think next slide, that may be the last, yes. HHS resources regarding Section 1557. So when the slides are given out, you'll see these links to HHS website pages that answer FAQs about Section 1557. There's a fact sheet. There are sample notices of non-discrimination and notices of availability in multiple language, and also the text of the extensive 2024 final rule, if you're interested in reading that.
I will say too, the text of the final rule, although it's very extensive, if you want to search a specific provision and review the comments, because they do give helpful background in terms of what HHS is looking for compliance and also examples of what they're attempting to address through the rule. So it can be a helpful reference point. I know people don't have a lot of time to do those things, but you can Control F and kind of play around with it. So.
Well, this was excellent presentation and overview of a pretty complicated rule. I just have a couple questions, and then and David, I know you probably have a few questions, and some of the audience. Does the translation services apply to all of our patients or just only our Medicare patients?
It applies to all patients.
So every patient I have, regardless whether they're covered by Medicare or not, I have to offer free translation services.
For each patient that is directly affected by, or could be, I think, implicated in, or is directly affected by the services provided by the health program services, yes.
Okay, does a practice that's smaller than 15 people have to comply to this rule? I mean, I know you went through that it did, but it's a little confusing there.
A practice with less than 15 people or 15 employees has to comply with all the provisions of the rule except for the Section 1557 coordinator and setting up the grievance procedure, yes. So the notice of availability, the notice of discrimination, all of that is required of all entities and all employees. All physician practice.
So is this rule, like, compare this rule to HIPAA as far as the effect and the size of the effect, the amount of changes that you consider that are going to happen in the healthcare system?
Well, OCR also administers in compliance with HIPAA. So they're both big rules. They had kind of different purposes and different impacts, but they're both very large rules, and they both are going to have a strong impact on all the covered entities that they address.
I think that HIPAA is, just to add to what Stephanie said, because I think Stephanie is absolutely correct. And I think this one can change, right? Like, that we've seen already, there's been litigation filed with respect to some portions of section 1557, in terms of, sexual, some of the requirements of the non-discrimination language that's in there. So those cases are sort of ongoing. And also, as Stephanie walked through, the changes in administration result in changes in the way HHS is, implementing the requirements and changing the requirements. So that also can be impacted by, we're in an election year. And this is, the breadth is very large, but like HIPAA, HIPAA covers any covered entity as defined by HIPAA and covers all, the PHI that's held by those entities. I think we're just more accustomed to HIPAA because it's been around since the 90s. So everybody is very accustomed to the compliance program and what that needs to look like for HIPAA.
Okay, so can I go back to I want to go back to some definition issues. So be very careful with the difference between translation and interpretation. So I'm aware that, yes, this rule requires a lot of translation of documents that are announcements about policies and procedures. The interpretation is a separate issue. Does using a language line qualify for meeting the rules of having translations, interpreters of the needed languages?
You're on mute, Stephanie.
So I think is that you, or would you like to handle that question?
Me?
Yes.
I can start. So you're talking about like telephonic translation services that like.
Yeah.
I believe that does comply.
Those interpretation, not translation.
Yes, for yes, for oral oral translation. I'm looking for the wrong word.
Verbal translation of a document rather than
no. I'm not talking about documents. I'm talking about interpretation. You have a patient, you have to offer a patient interpretations. Is that part of the rule? You have to offer the patient interpretation?
Yes, you have to have a qualified person who can speak to them in their native language as you're speaking to them. Is that
right? So if you don't have the person on site, can you use a translation line?
Telephonic, yeah.
Yes.
Okay. And then the issue of putting up statements in 15 languages. I mean, a lot of places not going to have enough space to do all those posting. So can you refer to a website or something like that? Or does it have to be on site that the announcements have to be made?
You have to post the notice of availability, and you have to provide it in certain written and electronic documents.
So the notice would go, so if your informed consent forms are electronic, the notice goes with your electronic consent forms, that it's available in 15 different languages. Does that make sense?
Well, but you have to put, in order to make the notice that something's available in 15 languages, you have to do it in 15 languages. So you have to have a sign in your waiting room that says in 15 different languages that says we have things available. And that's what you're saying, right?
And actually CMS has provided language in those languages inside of the rule or in a resource area that so you can just cut and paste that, and even tells you what size it has to be.
Well,
So
that's what I'm actually worried about that, Tom, because they're using 20 font. So it's not a small sign. So
no, you're gonna, and you remember you have to have two notices. You have to have that notice and the notice of non-discrimination. Correct, Stephanie? There's two different notices now, in addition to the HIPAA notice and everything else that you have. So you better get some more wall space, I think.
Unrealistic. I think this is for most offices, that see patients on a regular basis. It's quite unrealistic. That's what I said before we started the meeting, but for those of you who don't know, we were talking a little bit before, that these kind of rules have applied for many years to hospitals, but having to do it at the local level is very frightening.
And it's by November. If I remember what you just said, it's in early November that you have to have the notices up, correct?
Yes, the notice of availability at least.
And you had mentioned at one point that there could be private actions or enforcement actions. Can you kind of elaborate what that looks like?
So a private right of action is is basically the right for an individual to sue. So if a person or an individual thinks that Section 1557 has been violated and that they've been a victim of this violation, then they can bring a lawsuit against the practice under 1557 and get compensatory damages, money damages for this, if they win.
And has anyone done that in the past and won? Is there any, is there any kind of legal case history here?
There is legal, I'd have to check and see who won. There have been a number of private actions, yes. I'd have to check and see which ones won.
Stephanie, would it be helpful in that example? I know, so Stephanie's done a lot of speaking on this, and there was a podcast that she did where you kind of walked through that. If you give a hypothetical example of a long-term care facility and a resident, they could theoretically file a complaint with HHS and also a private lawsuit, correct? If they felt that they were discriminated against in violation of Section 1557?
Yes.
So does this apply to, in addition to physicians' offices, to long-term care facilities, skilled nursing facilities, rehab facility? I mean, is this like everything in the healthcare system has to do this?
It's anybody who gets federal financial assistance. So long-term care facilities, skilled nursing facilities, definitely. Assisted living facilities, not all of them receive federal financial assistance unless they're getting Medicaid. So it would only apply to those that receive that funding. But otherwise, yes, home health agencies, the whole gamut.
So Tom, like a lot of people are going to fall within the scope of the law because of what Stephanie just said. Because a lot of people do get federal financial assistance.
So basically any kind of practice that takes any kind of public assistance or Part B, or other programs in Medicare, basically this is an all-comers. This is an all-comer.
The big ones would be Medicare and Medicaid, but yes.
And you say about the training program, can you describe what is required in the training what they're looking for in the training program?
There's not a whole lot of guidance as to what they're looking for in the reg, no. In my personal opinion, they're looking to make sure that everybody understands the rule, that understands exactly what the basis of discrimination are, how they can be expressed or shown, how to address if they are shown, and what to do with reporting, those kinds of things. So, policies and procedures for all of that kind of information.
And I would say too on that, it's relevant employees, right, Stephanie? And there's a definition of what relevant employees means. So basically interacting with patients and anyone who's making decisions that involve patient care.
And anybody who's also involved in financial services, yes.
Yeah.
So you're billing.
Oh, so even your back room has to have training on this.
Billing and collection, right?
Yeah.
And then, think about two new staff who are hired as well.
They have to be trained within a quote unquote reasonable amount of time.
I think for most organizations that deal with HIPAA and all those, I think we're used to that kind of training. So that's, they'll just get folded into it. I don't see that as the major difficulty. I think the major difficulty is the actual procedure of putting together these policies and documents that are going to be fairly time consuming at the beginning and disruptive to a lot of the practice. And then the issue of if you're working in certain areas like FQHCs, which have a lot of patients of who need this kind of assistance to begin with,
Yes.
they're really going to be struggling with this. So that's they don't have a lot of economic wherewithal to begin with, and now they're going to have to deal with this on top of it.
That's a great point, Dr. Sweeney. I'm on the board of one, and they, you know, and they may have qualified folks who would qualify under the rule as qualified translators, but it's a great point to make, because they don't, they're strapped certainly for resources, and they do have a wide population base who does has limited English proficiency. So.
Yeah, I know that at Rutgers in New Brunswick, I mean, we actually established a program to train people for interpretation in Spanish, but that's only one language.
Yes.
Now, so I don't know of any place that trains people in 15 languages, so, and of course, those are the languages of, Tom, you put out a list of the languages from at the state basis. Although I'm looking at the law, and it looks like it's more local than that. You could use the argument of whatever the languages were in your community, right, Stephanie? I'm not sure it has to be the state. You don't have to be.
It says in your area, but area is
Yeah.
not actually defined. So
So you may only have, so although there's 15, up to 15, you may have like 5 languages in your area, right? I mean,
no, that you would put the top 15.
Well, but you may not have 15. What I'm saying, you may not have that's a big variety, but you may not have that many in a lot of the areas, is all I'm saying. Because if you define your area, for instance, as your patient population, people who see you on a regular basis, what languages they speak, and they may not be 15, they may only be 5 or 7 or 8.
The rule doesn't make an allowance for that type of situation. It just says 15.
But but you don't have 15 languages to use. What do you do with the other, you get down to after you go to, you have some patients who speak Russian and some people who speak Chinese and Spanish, of course, in New Jersey, and Italian and that kind of thing. Once you get down to, I don't know.
Well, that's where that state list, David, that's where that state list comes in handy.
Right.
Dr. Swee, is that state list tells you, I'm sorry, you're cooking in the background. That state list tells you that these are the 15 languages in your state, and to be legally protected, I would, and Stephanie and Alexandra tell me if I'm off, but to be legally protected, those are the 15 languages that I would focus on.
That's right. I think that's what Stephanie was saying. So CMS has the list hyperlinked on the rule and on their resource page that gives you by state the top 15 languages, which is what you just said, Tom. And
but if the rule says area, that's not state. I don't understand how you jump from state, to
because that is so when you're following a federal regulation, if they publish something that says this is what we find acceptable, that's what you kind of shoot for, because anything that's different than that, you'll have to make an internal justification about, and it may cause you difficulties later. So those are the 15 that you have to shoot at.
all right.
Does anybody else have any more questions?
I don't see any coming in. If you want to unmute yourself, you could, if you want to ask a question. Thank you both of you so much for joining us today. I'm sure there'll be lots of extra questions. We appreciate the honor of having you here today. I do have a couple other things to follow up with the rest of the crowd, and I'm going to release you guys. Here's ways to connect with Stephanie and Alexandra and Alex on their website, on their Facebook, on LinkedIn, on Twitter. I'm sure this is the first you've heard of it, and it won't be the last you'll hear of it. I have a feeling that this will be a lot of things are going on, and we appreciate, we know tonight's a debate between the two presidential candidates. Probably lost a little language. We're kind of competing against a bigger, bigger audience for political talk and people's brain categories, but I am certain that we'll have a lot of people on the replay of this So we're very grateful that to have you. And again, they have resources. We have resources on policyandmedicine.com. And this will be this webinar will be an article as well. So thank you very much for participating with us today. I just have one other updates, and that is, again, this is for updates for if you want to go to Policy and Medicine. On this slide, that'll give you where you can find it. And then if you go to the next slide, this past year, the DEA in April of last year passed certification requirements to renew your DEA licenses for 8 hours in substance use disorder and training on opioid or substance use disorder, as well as safe pharmacological management of dental pain to apply for renew their DEA license. We are partnering with the Medical Society of New Jersey to offer this course, and we encourage you to sign up. There's a $100 discount for Medical Society of New Jersey members. If you go to the next slide, in addition, if between now and next year, your CME requirements will come up. We have a course, and we're partnering with the Medical Society of New Jersey on as well, which you can meet your CE requirements, your 2 hours of controlled substances. If you do the MADAC course, if you do the DEA course, that also applies to the New Jersey controlled substances. But if you'd already done your DEA license, or you need 2 hours, and you're not going to get a DEA license this year, this is a good course for you to have. So that's all I have to say. Thank you. And do you want to say anything, Dr. Swee, at the end here?
No, other than thank all of you in participating in this very important topic. And I totally echo Dr. Sullivan's, Mr. Sullivan's statements that we'll be talking about this a lot during the year, and we'll be working hard on helping practices of all sizes and meet the requirements. And of course, the other information that you're providing as well will be very useful. I look forward to taking those courses. Anyway.
Thank you
Thank you
for having
guys
us.
for having us.
Thank you.
Thank
All right.
you.
Grateful to have
Bye-bye.
you. Thanks, man.